This is the reading of your jury charge performance challenge for week number 7. Members of the jury, the evidence in this case has been completed, period. In a moment, I will read you the law which you must apply in order to reach your verdict, period. But first, I want to mention a few things that you need to keep in mind when you are discussing this case in the jury room, period, paragraph. It is my job to decide what rules of law apply to the case, period. While the lawyers may have commented during the trial on some of these rules, you are to be guided by what I say about them, period. You must follow all the law as I explain it to you, period. Even if you disagree or don't understand the reasons for some of the rules, you must follow them, period. No single instruction describes all the law which must be applied, period. Therefore, these instructions must be considered together as a whole, period, paragraph. During the course of the trial, you receive all of the evidence that you may properly consider to decide the case, period. Your decision must be made by applying the rules of law which I give you to the evidence presented at trial, period. Neither sympathy nor prejudice should influence your decision, period, paragraph. If you decide that the prosecution has proved its case beyond a reasonable doubt that the defendant has committed the crime as charged, it will be my job to decide what the punishment might be, period. You should try not to guess what the punishment might be, period. It should not enter into your consideration at any time, period. The defendant is charged in 3 counts in the information, period. The charge against the defendant is sexual assault in the 1st degree and the crime of kidnapping in the 2nd degree, period, paragraph. All of these acts were alleged to have occurred in the city of Albuquerque, state of New Mexico, on or about June 13, 1996, period. The defendant has pled not guilty to both charges, period, paragraph. The information is a mere accusation against the defendant, and it is not in itself any evidence of the guilt of the defendant, and no juror should permit himself or herself to be influenced to any extent, however slight, against the defendant because or on account of the filing of such information, period, paragraph. At times during the trial, the lawyers made objections to the questions asked by the other side, and to the answers of witnesses, period. Do not draw any conclusions from such objections or from my rulings on the objections, period. These only related to the legal questions that I had to determine and should not influence your thinking, period. The arguments, statements and objections made by counsel to me or to each other, and the rulings and orders made by me, comma, and the remarks made by the court during the trial and not directed to you should not be considered by you in arriving at a verdict, period, paragraph. The court did not, by any words uttered during the trial, and I do not, comma, by these instructions, comma, give or intimate or wish to be understood by you as giving or insinuating any opinion as to what has or has not been proven in this case, comma, nor as to what are or are not the facts in this case, period, paragraph. Finally, you should consider all the evidence in the light of your observations and experience in life, period, paragraph. Every person charged with a crime is presumed innocent, period. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, comma, after considering all the evidence, comma, you are then convinced that the defendant is guilty beyond a reasonable doubt, period, paragraph. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged, period, paragraph. Reasonable doubt means a doubt based upon reason and common sense which arises from a fair and rational consideration of all of the evidence or lack of evidence in the case, period. It is a doubt which is not vague, comma, speculative or imaginary doubt, comma, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves, period, paragraph. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, comma, you will find the defendant guilty, period. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty, period, paragraph. The mere number of witnesses appearing for or against a certain proposition does not in and of itself prove or disprove that position, period, paragraph. You may have to decide what testimony to believe. You should carefully consider all of the testimony given and the circumstances under which each witness has testified, period, paragraph. Consider each witness's knowledge, comma, motive, comma, state of mind, comma, demeanor, comma, and manner while on the stand, period. Consider the person's means of knowledge, comma, ability to observe and strength of memory, period. Consider also any relationship each witness may have to either side of the case, semicolon, the manner in which each witness might be affected by the verdict, comma, and the extent to which, comma, if at all, comma, each witness is either supported or contradicted by other evidence in the case, period. You should consider all facts and circumstances shown by the evidence which affects the credibility of the witness's testimony, period. Paragraph. You may believe all of the testimony of a witness, comma, or part of it, comma, or none of it, period. Paragraph. There are two types of evidence from which you may properly find the truth as to the facts of the case, period. One is direct evidence. The other is circumstantial evidence, comma, that is, comma, the proof of facts from which other facts may be reasonably inferred, period. The law makes no distinction between direct and circumstantial evidence, period. Paragraph. The prosecution and the defendant have stipulated to certain facts in this case, comma, and you were so instructed about these stipulations during the trial, period. A stipulation renders unnecessary the presentation of any evidence to prove those facts, and the jury must regard those facts as being conclusively proved, period. Paragraph.